Welcome to our LLA tutorials. Please like, share, and subscribe. So today we are going to learn about South African Constitution. So where can we find the law? Firstly, the first place to start is the Constitution. The Bill of Rights is an important part of the Constitution. The right to life is one of many things stated in the Bill of Rights, as is the right of everyone not to be treated or punished in a cruel, inhumane, or degrading manner. In our legal system, such a case has been documented in which the death penalty was considered. S versus McQuanian was decided in 1995. For exam purposes, be aware of the court's decision in this case.
Lawyers use authoritative sources to reference law and reading the law. Authoritative sources provide authority or weight to lawyers' arguments. Sources of authority include legislation, statutes, and parliamentary acts. Legislation is the most authoritative source of law. Legislation is also known as statutory law. Legislation is made up of rules enacted by Parliament, provincial legislatures, and local governments, which are contained in Acts of Parliament, provincial ordinances, and municipal bylaws. The Constitution governs all law, not just legislation. No other law may be in conflict with the Constitution. Acts of law are published in the Government Gazette, an official publication that includes public notices. Higher courts cases, only the ones considered important, is documented and published by various publishers, that is South African law reports. The decision taken by the court, also known as the ratio decidendi, which translates to the decision or reason for the decision, is important as this would have to be adhered to in the lower courts. Obiter dictum refers to judge's remarks in passing and are casual remarks made by the judge. They do not create a precedent nor applicable in resolving the case or binding, but they may have persuasive force, such as principle of the case is broadly formed by the judge, then necessary to cover facts. Judge makes an incidental remark. Judge asks and answers hypothetical set of facts. The judge quotes a set of facts. The judge quotes similar cases or gives an illustration. Another source of the law is common law, law of the country not contained in legislation. Writings of 17th and 18th Roman Dutch jurists. Consider Roman law, or specifically Justinian's Corpus Juris Civilis, influence of English law bringing together with it case law. Custom is the third source of law, developed from community customs and passed down from generation to generation. Certain conditions must be met in order for customary law to be recognized. REROC must be met in order for customary law to be recognized. REROCD. Custom must be reasonable, and it has been around for a long time. The community has generally recognized and observed. The contents of the custom must be clear and unambiguous. African indigenous law is largely unwritten, accepted in the Constitution, and must be applied where necessary, largely thought to apply only to blacks. But the Constitution states that its application is required where necessary. And the final sources are other sources include foreign law from another country. Remember, the Roman influence must have a connection to South Africa. Modern writers are not authoritative sources of law, but they can have a significant impact in debating legal principles or rules. Journals of law. So, in terms of the Constitution and how it applies to you, a country's citizens elect a government to protect their rights. The government is also expected to develop and advance their country politically and economically. The government should also be concerned with issues such as health, the environment, education, tourism, housing, and population growth. To effectively govern the country, the government will need certain powers. Power cannot be endless. Power must be balanced. Otherwise, unfair laws may result. The rule by which a country is governed is contained in the Constitution. It is usually very long and sets out structure and function of government. It also sets out standards that will have to be used to protect the individual against abuse of power by the state. The South African Constitution was adopted in 1996. Our Constitution's history. South Africa first created the Interim Constitution of 1993, which was later replaced by the Constitution of the Republic of South Africa. In 1996, we had previous constitutions, such as the 1910 Constitution, which established the Union of South Africa. 1961 South Africa became a republic. In 1983, the tricameral parliament was established, with 3 houses for the various ethnic groups: white, Indian, and colored. These constitutions were not democratic because only a small percentage of the country, primarily the white population, was allowed to vote. As a result, it was unjust to Indians and other races. Sharpeville and Soweto experienced uprisings against the apartheid-style government in 1960 and 1976, respectively. Other countries imposing sanctions against South Africa felt the pressure to end the apartheid-style government. All of this pressure resulted in Nelson Mandela's release and the unbanning of previously banned black movements such as the PAC and ANC in 1990. These pressure reliefs paved the way for negotiations to begin in order to establish full democracy. However, a temporary constitution was required in the interim, which resulted in the Interim Constitution 1993, which went into effect on April 23, 1994. The reason it was called interim was because no democratically elected government had been formed at the time. It was 2 years old, and all South Africans could see their ideas being incorporated into the constitution. The final constitution was signed on December 4, 1996. What is contained in our constitution? Our constitution is a blueprint of the running of our country. In broad terms, it covers the following: governing of the country at national, provincial, and local levels, legislative powers and processes at each level, administration of justice by all different courts, rules relating to elections, function of police, army and other security services, manner in which the country's finances should be conducted, provisions regarding power of traditional leaders, establishment of institutions such as Human Rights Commission etc. to support constitutional democracy. The 9 provinces, 11 languages, national symbols such as the flag. Very importantly, it contains the Bill of Rights, which contains the fundamental rights of all South Africans such as right to equality, right to life, religion, and more. Why is the Constitution so important? Remember it as SSJB, which stands for Supreme Law of the Country, Separation of Powers, Judiciary Authority, Bill of Rights. The Constitution is the supreme law of the country, which is the highest law, and everyone is subject to it, including the President, as well as organizations or institutions and state organs. As a result, all legislation can be challenged in court under the terms of the Constitution and changed or removed if it is found to be inconsistent, that is, it does not agree with the Constitution. The state's powers are divided into 3 branches. Power is divided in order to prevent one branch from becoming overly powerful, which could lead to abuse. You can remember them by LEJ, which stands for Legislative Authority, which makes laws, Executive Authority, which applies and carries out laws, and Judicial Authority, which decides legal disputes. For example, if the same branch of government made the law, applied it, and carried it out, as well as decided questions about that law, there would be no way to question its application and execution, or its constitutionality. Judicial authority is concerned with the courts. The Constitutional Court is one of the most important courts. The Constitutional Court, the Supreme Court of Appeal, and the High Courts have the final say in constitutional matters. If legislation enacted by Parliament violates the Constitution, the Constitutional Court has the authority to change or repeal it. Although the Supreme Court of Appeal and High Courts may hear constitutional cases, the Constitutional Court has the final say. For example, If the same branch of government made the law, applied it, and carried it out, as well as decided questions about that law, there would be no way to question its application and execution, or its constitutionality. Judicial authority is concerned with the courts. The Constitutional Court is one of the most important courts. The Constitutional Court, the Supreme Court of Appeal, and the High Courts have the final say in constitutional matters. If legislation enacted by Parliament violates the Constitution, the Constitutional Court has the authority to change or repeal it. Although the Supreme Court of Appeal and High Courts may hear constitutional cases, the Constitutional Court has the final say. The Constitution established a number of state institutions to support our democracy, including the Public Prosecutor and the Human Rights Commission, such as the Commission for the Promotion and Protection of Cultural, Religious, and Linguistic Communities' Rights, the General Equality Commission, the General Auditor, the Commission for Elections, Broadcasting's independent regulatory authority. What are fundamental rights? According to the Bill of Rights, many fundamental rights are enshrined in our Constitution, which we refer to as our Constitution because these fundamental rights were drafted by South Africans. When the Bill of Rights was drafted, it took into account the constitutions of other countries. By doing so, and keeping it relevant to South Africa's history, we can prevent future human rights violations. What are the various types of fundamental rights? The rights documented range from basic survival needs such as water and food to religious freedom. Individuals are protected by these rights from state abuse. There are 3 types of fundamental rights. Rights of the first generation, also known as blue rights. There are 3 types of rights: civil rights, procedural rights, and political rights. These rights protect Republic citizens from abuses of power by state officials. Examples include the rights to equality, human dignity, life, freedom of expression, and personal security. Rights of the second generation, also known as red rights, they gained prominence during the socialist revolutions, as they are concerned with socio-economic issues. Examples include the right to an education, the right to health care, and the right to adequate water and food. Green rights are the rights of the third generation. It has more to do with a group than an individual. Right to clean is one example. What constitutes a fundamental right? The definition is difficult to provide, but we can say the following: every person is born with human dignity, and it is that dignity that entitles that person to human rights. These are your natural rights. In other words, they are fundamental to every human being. You do not have to work for them or qualify for them. They are present in everyone and cannot be removed by the state. Some fundamental rights are limited in some cases, but this can only be agreed upon and documented in the Bill of Rights. 1. This Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. 2. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. The application of the Bill of Rights. The Bill of Rights can be applied in 2 scenarios: between the state and individual or private institution, or between individuals or private institutions. Let's look at the state and individual first. This is concerned with state organs, where any act which infringes on the Constitution may be challenged and ultimately declared unconstitutional. Between individuals, horizontal application of the Bill of Rights is applied between individuals or private institutions. Typical application would be a dispute between individuals in the sense that they may unfairly discriminate against one another in a job situation. What are the fundamental rights? Some of the rights enumerated in the Bill of Rights are limited because of how they are phrased or described. Subsections 3 to 5 of the Bill of Rights address unfair discrimination. The word unfair before discrimination implies that discrimination may be constitutional in some cases. When a woman applies for a job at the municipality, she encounters a long line of mostly male applicants. The interviewer walks out and tells her to leave because the job requires heavy lifting and is only for men. The woman may consider this to be a case of discrimination, but one must also consider the municipality's case. The woman may be injured easily and can face other types of claims against the municipality. Some constitutional issues, such as the right to life and the right to make reproductive decisions, may be in direct conflict. Such disputes must be resolved by a judge. When the state declares a state of emergency, certain fundamental rights may be temporarily suspended. This could happen as a result of war, political unrest, natural disasters, and so on. Certain rights, on the other hand, cannot be waived, removed from individuals. Non-derogable rights is a table in Section 37 of the Bill of Rights that explains which rights are not derogable. For example, even in an emergency, you may not be tortured. The Bill of Rights Section 36 Limitation Clause. This section establishes the criteria by which rights may be limited. That is, if the state wishes to limit a right, it must meet the following criteria. The law that restricts the right must be of general application, that is, it must apply to everyone. In an open democratic society based on human dignity, equality, and freedom, the limitation must be reasonable and justifiable. That is, there must be a good reason to limit the right within the framework of the Constitution. All of the following must be taken into account. What exactly is the nature of right? What is the limitation's purpose, and how important is it? What is the nature of the limitation, and how severe will it be? That is, what is the nature of the limitation, and how long will it last? What is the relationship between the purpose and the limitation? That is the relationship strong enough to be justified? Is there a less restrictive way to accomplish this goal? That is there another way around with less restriction? The Constitution's influence on South African law. We've had a democratic constitution for nearly 2 decades, and as a result of a number of cases heard, some changes to our law that were shaped by the Constitution may have occurred. Various legal disputes. Everyday events can give rise to a variety of legal disputes. These disagreements cover civil, criminal, and constitutional issues. Civil cases are those in which the government is not involved. For example, in a car accident, person A sues person B, claiming that B was at fault and must pay for the damages caused. Criminal cases involving the state, where the state has a vested interest in the protection of the community, province, and national levels. In other words, the state will not tolerate drunk driving. Constitutional cases necessitate the interpretation, protection, or enforcement of constitutional matters by the Constitution, and may also include fundamental rights such as the Bill of Rights. A constitutional case may involve the state, individuals, or private institutions. The appellant and respondent are the parties. Advocates or attorneys may act as their legal representatives. A judge will serve as the presiding officer. Constitutional issues may be heard by high courts, the Supreme Court of Appeal, and the Constitutional Court, with the Constitutional Court having the final say. So we have reached the end of Chapter 10. Please like, share, and subscribe to Ella Law Tutorials.